Welcome to those of you that have joined us. We have just opened the live link, so we're just going to wait for a few minutes to allow everybody to join before we start. Welcome to those of you that have joined us. We've just opened the live link. We have a few minutes, so we'll just wait for people to join before we start. Welcome to those of you that have joined us. We've just opened the live links. We're just going to wait for a few minutes to allow everybody to join us before we start. Welcome to those of you that have joined us. We've just opened the live links. We're just waiting for a few minutes to allow everybody to join us before we start. Whilst we are waiting for everybody to join us, I shall just remind you of the house rules. So just to let you know that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions into the Q&A box at the bottom of the screen, and our speaker will try to come to those at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that our speaker will not identify you in their response. And just to remind you that we now have a separate section on the Five Stone Buildings website where you can find copies of this webinar and any previous webinars that have taken place. I will now hand over to Will.
Thank you very much, Jo. And I apologise at the start if I have lots of sniffles today, because we seem to have a bug going around the whole of Chambers at the moment. And it was my turn, obviously, this week to get it. But I'll try and press on as best I can. So today I wanted to talk about a case I was involved in, a trial last year, Sangha and Sangha, in which judgment came out in June this year. And so just to give an overview, first of all, it was a claim involving property in England and India worth potentially as much as £40 million, although there was a significant question mark over the value of the Indian estate. And we had two actions that we were dealing with in the first trial. I say the first trial because there could well be a sequel in this case. So firstly, a will challenge and a proprietary estoppel action. The judgment is no fewer than 402 paragraphs long. So you may feel as ill as I do after reading that amount of paper. So I'm going to hopefully try and summarize it as best I can today. But there's a number of important points buried in it. So firstly, in relation to the legal and evidential burden in will forgery claims. Secondly, in relation to the effect of a revocation clause in a foreign will on previous English wills. Thirdly, and this is, I think, new law, totally new law, is in relation to the effect of an annulled bankruptcy on joint property. So everyone will know that where you have a bankruptcy, that results in joint tenancies being severed in relation to property. But what has never been considered before, to my knowledge, is if that bankruptcy is subsequently annulled, whether the severance of the joint tenancy is reversed. And that's something that was dealt with in this decision. And then also whether the presumption of due execution can apply where a will is not executed in accordance with the order of events set out in the attestation clause. Now, there's a number of other legal points in relation to the Estoppel claim, because there's so much material to deal with, and we've only got, I think, 45 minutes, an hour most. I'm not going to deal with too much on the Estoppel action. I will give something of a summary of it, but I'm going to principally concentrate on the will challenge. So this is a picture of the Golden Temple located in the city of Amritsar in the Punjab. And this case really was a tale of two marriages in the Punjab. So the Golden Temple is the preeminent site, a spiritual site of Sikhism. And I mention it because the case involved a Sikh family and two marriages which the deceased, Hartar Sangha, underwent in the Punjab in rather unusual circumstances, as we'll see. So there was reference in the judgment to the first family and second family. The first family, so Hartar married Diljit in an arranged Sikh marriage ceremony in October 1962. Now, this marriage was not registered. That's not a bar to validity under Indian law. And Diljit was subsequently referred to as his wife in multiple documents. For example, a will that the deceased made in 1979, which divided his estate between Diljit and his two children by that marriage, Sandeep and Mandy. And the people I was acting for at trial were Sandeep and Mandy and Diljit's estate, Diljit having survived Hartar but then died a couple of years after he died. So Sandeep and Mandy were born in 1969 and 1972 respectively, and the family lived together in Ilford and from 1990 in Chigwell in Essex. In 1983, Hartar had purchased a plot in Chigwell in which the house was built for the family, and that was steadily built over the years. And in 1990, Hartar's sister Jagpal, who's quite an important character in these proceedings, comes to live in the Chigwell house. The picture on the right is a picture of the Chandigarh Rock Garden, as it's known. And it's another destination on my wish list in addition to the Golden Temple. And that was a garden which was started from waste materials in the city by a government official secretly in his spare time. That the reason I have Chandigarh as a destination there was because in 1991, Diljit and Jagpal fell out, and Diljit asked Jagpal, Hartar's sister, to leave the property in Chigwell. She did, but Hartar went as well, and they went to Chandigarh. And in 1992, without there being a dissolution of his marriage to Diljit, Hartar married again, this time to Jaswinder, who is the claimant in both the Estoppel claim and the probate claim. And this was an arranged marriage. Indeed, Jaswinder met Hartar for the first time on the day of the ceremony itself. And the marriage certificate that was this time issued states that Hartar was unmarried. On 1st of March 2001, their son Harbison was born. So that's the second family. Now, some further background to Hartar's life and business interests. So by the time that he left to go to India in 1991, he'd built up considerable business success, building up a firm of building merchants called SBM in East London initially, which expanded into Brentford, Finchley, Swiss Cottage and Southwark. And in 1990, a property which took on quite a lot of significance in the proceedings was purchased at 103 to 107 Windmill Road over in Brentford, which had no fewer than 18 residential units and a shop downstairs. And much of the value of the business was really in the property itself, rather than the building merchants, as we'll see. So Sundeep, for whom I was acting, he first worked for Hartar at SBM from the age of 10, obviously part-time whilst he was at school. Of course, accepted that Hartar promised from a very early age onwards that he would succeed to the business. And from 1987 onwards, he was working more full-time as salesperson. And from 1991 onwards, he was left in de facto control of the company when Hartar went to India. Now, by this time, SBM was in quite a poor state with substantial sums owed to various creditors and money being transferred by Hartar over to India. In 1994, the business failed. Now we go from the lovely surroundings of the Golden Temple to the Millwall Football Club. And I say that because one of the properties that was at issue here, the warehouse, was very close to Millwall. So the main warehouse of the business was transferred by the mortgagee on the failure of the business to Jagpal, who, as a reminder, was Hartar's sister, for 215,000. And in 1999, it was retransferred by Jagpal to Hartar and Jaswinder. Now, Jagpal and Jaswinder, this should be Hartar and Jaswinder, then go on and sell the warehouse for in excess of £2 million. Now, what Jagpal said was that it was agreed in 2002 that she would receive 250,000 and an interest in a property purchased by Hartar and Jaswinder in Gillingham in exchange for all of these arrangements. But that was never put into effect. And all of this was the start of a feud between Jagpal and Hartar and Jaswinder, which lasted until close to his death in 2016. The confession in Chandigarh, so in 1994, Sundeep went over to Chandigarh and Jaswinder was there in the family home, and Hartar told him over dinner one evening that he had married Jaswinder, which obviously came as something of a shock. Hartar asked Sundeep to deal with the family business in England and said that Hartar would deal with his developing Indian business. And Hartar said, well, on my death, you will get everything in the UK. So from 1994 to 2011 onwards, once SBM had broken down, Sundeep ran his own builders merchants called Waterforce Limited at Windmill Road. This is the Brentford property. And he inherited the goodwill and business that SBM had developed there and was entitled to keep the profits. He had to pay rent to Hartar, some of which was paid to Diljit. And the other former outlets of SBM, so the various other properties which Hartar held across London and which had previously been used as part of the business, were rented out on what was called what was described in the proceedings as a package arrangement, where the tenants essentially paid a fee for being able to operate their own business from those locations. And the court found that Sundeep's role in relation to Hartar's remaining business was limited. So there was some collection of rent and errands by him, but not much else. 2002 was quite a key year in the chronology. And in that year, Hartar told Sundeep that he had brought Jaswinder over to the UK, and that led to a series of events. So firstly, he told Sundeep that subject to a payment of £3,000 a month, which was to go to Hartar, Sundeep could keep the rents from the residential units of Windmill Road, he also said that Windmill Road belonged to Sundeep. And there were further promises made in 2009, 11, 15 and 16 that the UK property and business would be transferred to him. From 2002 to 2007, Sundeep, having heard the news about Jaswinder coming over to the UK, entered into a period of semi-estrangement from his father. And he and Diljit looked into the possibility of obtaining financial remedies on a divorce. But in 2007, there was a reconciliation between Sundeep and Hartar. Separately, also in 2002, Jagpal got married. And that led to an escalating feud because Hartar believed that Jagpal should give up an interest which he had given her in the family property in Chandigarh, believing that that was only meant to be held by Jagpal until she was married. And this led to a series of court cases over in India between the two of them. We missed the 2003 will, there we are. So the 2003 will that was made by Hartar dealt with the Indian estate only. That was something which was an issue between the parties, but conceded eventually at trial by Jaswinder. Gave all of Hartar's Indian estate to Jaswinder and Harbison. It revoked all previous wills, but without specific reference to the 1979 will, in which Hartar had divided his estate between Diljit, Sundeep and Mandy. And so there was a question over whether the 79 will was still in place in relation to the English estate. It referred to the failure of Jagpal to transfer back her share in the Chandigarh house. And this will was made and registered with the aid of an Indian lawyer. It's one of the interesting features of the Indian legal system, that you can go off and get a document such as a will registered, which you could certainly see the benefit of here sometimes, because you have to go in front of an independent notary or equivalent when it's signed. And a manuscript note was added later. It wasn't clear exactly when, but in the years afterwards, saying make sure no property goes to Jagpal, amongst other things. So Hartar was fairly clear on that. Sorry, it's somewhat slow to change, and it changes 2 slides at once. So the 2007 will, this was purportedly made in the year that Hartar and Sundeep reconciled, and it was made on a will form with no legal assistance. It was handwritten with one of Hartar's employees and a close friend and stroke contractor as witnesses to it. And there were no fewer than 10 signatures on it, which I think it was fair to say, from looking at the original, differed wildly from each other. Now, 9 of those signatures were in black, but one of them was in blue, and that colour matched up with a crossed out date, which was on the will form of the 25th of August, 2000. And that crossed out date was replaced with the 16th of April, 2007. And all the property in England and India belonging to Hartar was given under this will to Jaswinder. So, in other words, nothing for Diljit, Sundeep and Mandy, but nothing either for Harbison, his son by Jaswinder either. And interestingly enough, in terms of timing, as we look through the chronology during the trial, the will was purportedly made the day before Harbison went to school for the first time. So very different provision being made for Harbison as compared with the 2003 will. And the 2007 will said Jagpal should not get anything and should stay away from my family. So again, fairly strong view expressed there about Jagpal by the deceased. From 2011 onwards, so after the credit crunch, Sundeep's business Waterfalls failed in November 2011. And one of the Waterfalls employees, Mr. Gill, took over the commercial premises at Windmill Road and paid $6,500 a month for the privilege. Now, the arrangement was that the rent would be paid to Diljit, with residential rents remaining with Sundeep, subject to that £3,000 payment I mentioned, which was going to Hartar. Now, Sundeep was receiving, in terms of rent, payments worth something like 50 to 60,000 a year. before the costs which he incurred, such as electricity on the building, which, to be fair, was fairly significant. Mr. Gill fell behind on repayments. From 2011 onwards, Sandeep was not employed and did only a limited amount of work on the UK business. So he did some collection of rent and some management of Windmill Road. Instead, what he was concentrating on was caring for Diljit, who was suffering from a number of different health conditions. And significantly, in later years of his life, Hartar transferred very substantial UK property interests into the joint names of him and Jaswinder on the basis of beneficial joint tenancies. And those included, it was properties worth over 10 million, and they included the Chigwell property, which had always been a home for Diljit and previously Sandeep and Mandy. And so obviously you've got a very tangled situation there between the first and the second family. As I said, Sandeep spent much of his time looking after Diljit after being asked to do so by Hartar. In 2016, he found out that properties had been transferred into the joint names of Hartar and Jaswinder and raised the issue of Hartar. And Hartar said effectively that he had some form of tax issue to sort out and promised to deal with things properly on his return from his trip to India. But instead, he died in India on the 3rd of September 2016, and Diljit later died in March 2018. Now, then we come to the 2016 will, and this was a will that was produced by Jagpal, and she alleged that Hartar had made one final will a few months before his death on the 21st of March 2016. It was a will that was only raised in the English proceedings quite late in the day, so shortly before the trial due in May 2019, which was in the end adjourned. The original wasn't available at the trial. It was lodged in the Indian court, and the Indian court refused to release it. And that will divided the Indian estate between Sandeep, Diljit, Harbison and Jagpal in equal shares. So nothing for Jaswinder, in other words. And it said in relation to Jagpal, although we did split due to some reasons, I do not want to ignore my sister's support to me on many aspects. And significantly, it also contained a revocation clause, saying that this is my last and final will and all such previous documents stand cancelled. It's a typed will, in contrast to the handwritten 2007 will, with an Indian advocate and a mechanic acting as witnesses. So litigation galore, we had no fewer than 5 civil claims commenced following Hartar's death, 3 in India, one commenced by Jagpal, 1 by Jaswinder, 1 by Sandeep. There was a claim in England regarding Windmill Road, the property in Brentford. Jaswinder sought an account of rental proceeds received by Sandeep after Hartar's death and sought an injunction preventing him from having anything more to do with the property. And Sandeep counterclaimed for a declaration that Windmill Road and 6 properties put into the joint names of Jaswinder and Hartar were held by him on trust, were held on trust for him due to a proprietary estoppel. There was then a probate claim in England commenced by Jaswinder, in which she sought to prove the 2007 will, or alternatively the 2003 will, arguing at that time that the 2003 will extended both to England and India. And then we also had the spectre of criminal proceedings in India. There was a prosecution commenced in India against Jaswinder and her employee, Mr. Gurdeep Tiwana, who was also one of the people who was said to have been present at the 2007 will signing, in relation to the attempted murder of Jagpal and the alleged attempted murder of Jagpal and Jagpal's husband. In terms of the estate, there were various valuations given of the Indian estate, from anything from something over 10 million to as much as 30 million. It's not particularly clear what the valuation was by the end of the proceedings. In terms of the English estate, Jaswinder gave a value of 1.1 million to it. But there were properties which had passed to her by way of survivorship to the value of 10.079 million after they were put into joint names. So you can see it was no surprise that Sandeep had wanted to pursue the Estoppel claim. The twist was that during the trial, evidence came out, amazingly enough, given his wealth, of Harter having become bankrupt in 2012, when a pretty small creditor's debt led to a bankruptcy order, although the bankruptcy was annulled following payment of the debt. And our argument at the trial was that the bankruptcy resulted in the severance of the joint tenancies which had been established between Jaswinder and Harter, such as around £4.5 million more property fell into the estate. So here were the somewhat complex issues that we had in the probate claim. Was the 2016 will valid, or was it forgery? If it was valid, did it revoke all previous wills, including those which applied to the English estate? If it wasn't valid, or it didn't revoke the English wills, was the 2007 will valid? And then we had an issue if the 2007 will was proven to be a forgery, which is what we were saying. Did the 2003 will apply to English property at all? And did it revoke the previous 1979 will? If it didn't apply to the English estate or didn't revoke the 79 will, was the 79 will revoked by marriage, the marriage between Jaswinder and Harter in 1992? I put these following issues in red because they're issues that it was decided shouldn't be dealt with at the first trial in this case, were put off for later. So that issue, if there was an intestate in the English estate, who is the surviving spouse, which is a very unusual issue? And finally, where was Harter domiciled? And in terms of the legal aspects on the probate claim, you may be aware of the decision of the Court of Appeal on Re Payne, where the court acknowledged the importance of seeing the original testamentary document at a trial of a probate claim. But in this case, Deputy Master Bowles, who was the judge, held that it was possible to proceed with the trial without the original of the 2016 will. And that was mainly because all parties had been able to inspect the will via their handwriting experts. The court considered whether the execution of the wills was in accordance with Section 9 of the Wills Act. So it was said that the 2016 will was a forgery, and it was said that the 2007 will was a forgery. But there was also a point, as we'll see, that was taken on due execution in relation to the 2007 will. And the court didn't apply Indian law. There was no suggestion that any Indian law was any different. And then the court agreed with our submission that where the evidence at trial showed, as it did, that the 2007 will was not executed in accordance with the statement in the attestation clause, the presumption of due execution couldn't apply. I made a reference there to a previous case called Wrangle and Brunt. However, it's quite interesting, and this demonstrates how difficult it is to make technical arguments under Section 9 of the Wills Act about execution. Deputy Master Bowles held that the court's approach on due execution tends in favour of upholding the disposition, or in other words, the wishes of the deceased. So as I said, there were no fewer than 2 allegations of forgery, 2016 will and 2007 will. And the court held that in a forgery case, the burden of proof actually rests on the person propounding the will to show that it's valid. And that's agreeing with a decision of His Honour Judge Hodge in Face and Cunningham, an earlier decision from 2020. However, given the very serious nature of the allegation, the court held that the starting point really is that the greater likelihood is that a document produced as a will and apparently signed by the deceased is genuine. And reference there was made to some case law. When it came to the revocation clauses, so both in the 2016 will and the 2003 will, which were at issue, and the scope of those, it was held that the court could take into account extrinsic evidence of the testator's intention, but a party seeking to prevent an express revocation clause from taking effect according to the plain meaning of that clause has a heavy burden to overcome. So in other words, if you've got a will like the 2016 will, which says, I revoke all previous wills, but you want to say that because that will only applied to Indian property, it should not be regarded as revoking the previous English will. Really what you need is some evidence of the testator's intention in order to bypass the normal meaning of the revocation clause. And the court held that the annulment of a bankruptcy does not result in the undoing of a severance of joint property, given the terms of section 282, subsection 4 of the Insolvency Act. And we were able to cite some land registry guidance on this property, which supported that conclusion. So in terms of the 2016 will, we were actually neutral on that. There was a previous report that we'd obtained in which had been disclosed, in fact, to other parties, showing that it looked like that will was a forgery from an expert, albeit the expert had never been able to look at the original, so it's fairly hard for him to come to a definitive conclusion. But given that both Diljit's estate and Sundeep benefited under that will, we were neutral on that, and the battle instead was between Jagpal and Jaswinder. Some of Jaswinder's points as to why it might have been a forgery, in addition to her expert evidence, was to say that it was inherently unlikely that Harter would have made a will in favour of someone with whom he was in litigation for many years, and with whom he'd had a significant feud for some time. She also said that the 2016 will made no provision for her, and it had been drawn up by an Indian lawyer who had never previously met Harter. And she said that both witnesses, the advocate and the mechanic, expanded their story very significantly as compared with their affidavits, and the evidence was effectively being made up on the hoof. But despite the evidence about Jagpal's feud leading up to the 2016 will with Harter, the court held that the 2016 will was valid. And the court held that the witnesses were entirely credible. And the reason why witnesses' accounts had been expanded was because Jagpal was unrepresented and they hadn't been asked to give full detail before. The court found Jagpal's expert to be much more compelling, and said that Jaswinder, in a memorable passage, said that Jaswinder's expert gave answers which became incomprehensible white noise, and that she hadn't been willing to consider alternative explanations or expand her view beyond the very limited aspects of her responses. So I think that's a lesson in choosing a good expert if ever you get one. The court believed that Jagpal when she said that the letter to her from the deceased in 2016 indicating that he wanted to reconcile was true. Now this letter was put together with the 2016 will in support of it. And ultimately, the judge felt that it was clear from the evidence that Harter and Jagpal had been very close at one point. It was not unlikely that he would have wanted to make up as he became older. And this was despite the fact that Harter did not attend a family wedding in 2016, as the reason for that was that Jagpal would be there. And finally, it was felt that Harter would have regard to the fact that he'd passed substantial property over to Jaswinder via the transfers into joint names and other transfers into her sole name, in making no provision for her in respect of his Indian estate under the 2016 will. So we then came to construing the revocation clause in the 2016 will, and it was held by the court, notwithstanding Jaswinder's opposition on this point, that the revocation clause had the effect of revoking all previous wills, including all English wills. And the words of the will could not be clearer. All other wills are cancelled. And the court had regard to the fact that the will had been prepared substantially as a result of Harter dictating it. So he could have limited the scope of the revocation clause if he'd wanted to. And one of the points that Jaswinder made in opposition to our arguments on this was, well, if the revocation clause revoked all previous English wills, then that would result in an intestacy, and the court would lean against an intestacy. But the judge rejected that, saying that the fact that the revocation clause gave rise to an intestacy was not something which should result in a limited construction, as in, for example, the previous case of Benjamin and Bennett, as Harter had already taken many steps during his lifetime regarding his English assets. So the 2007 will, so this was effectively rendered moot by the decision on the 2016 will, even though a lot of time was spent on it at the trial. And I think it's worth covering just because it shows how difficult it is to maintain a forgery claim, which is one of the key lessons coming out of this case, in my view. So some of our arguments were as follows: that the will had only been produced when Jaswinder's solicitor, when Sundeep and Mandy's solicitors had stated that the earlier 2003 will only applied to Indian property. For quite some time in the Indian litigation, Jaswinder was saying that the 2003 will, so not the 2007 will, was the first and last will of the deceased. So that didn't square very well with the idea that the 2007 will was valid. The witnesses to the will had all worked for Jaswinder, and two of them had helped her in India to try and transfer properties into her name on the basis of the 2003 will. And after, indeed, the Indian court had imposed an injunction to prevent further transfers. And the witnesses had wildly differing accounts of how the will execution occurred. Two of them suggested that the blue signature I referred to earlier had been signed by Harter in 2007, when in fact the expert evidence on Jaswinder's side suggested that it may have been made back in 2000, so some time before. And even Jaswinder's expert acknowledged that Hartar's signature was vulnerable to simulation, and that the signatures on the 2007 will differed wildly amongst each other. We also ran an additional argument about due execution. So during the evidence, it emerged that one of the witnesses did not actually see Hartar sign the will or see the first witness sign. And that second witness was brought into the room after that happened. So what was required in these circumstances under Section 9 was for Hartar to acknowledge his signature to both witnesses, for the first witness to acknowledge his signature to Hartar in some way, and for the second witness to sign. I think it's probably enough for Hartar to acknowledge his signature to ask the second witness to come into the room and attest the will. But there was actually no evidence at all. The first witness who'd already signed did anything to acknowledge his signature to Hartar. But that argument, which is very much of a technical nature, was rejected by the court, despite the lack of evidence. And the court held that the witness would have been likely to have done something to acknowledge. In terms of the Estoppel claim, the court acknowledged that promises had been made to Sundeep that he would inherit Hartar's UK property in return for working on the UK business. But the claim failed in the end for a number of reasons. So firstly, and probably most significantly, I think in Deputy Master Bowles' assessment, rather than relying on his father's promises to his detriment, Sundeep hadn't actually been relying on the promises at all. Rather, he did what he did because of his father's domineering personality and his love for him, which is an interesting conclusion, because it perhaps shows that if you're an Estoppel claimant, if you're doing the right thing or following the strictures of your father, you're less likely to succeed than if you're doing the conduct you do, you're relying on your father's promises. So Sundeep had done very little work on the father's business from 1994 to 2011. The care for Diljit had not been in reliance on promises made by Hartar. And insofar as he suffered detriment during his period in charge of SBM between 1991 and 1994, that was dealt with by allowing him to establish his company Waterforce at Windmill Road with the benefit of the existing goodwill which SBM had. Sundeep had benefited from substantial income from Windmill Road. And then the court also took into account the fact that Sundeep would have 1/4 of a very valuable Indian estate, plus a substantial entitlement to the English estate, and said that this would satisfy any equity. The other issue was that the claim had been commenced prior to me being involved in the case, and the estate had not actually been joined to the proceedings. And although we tried to join the estate later on, that was not allowed by the court. And the court held that it was wrong to make the orders in relation to the property falling into the estate without the estate being joined. So what are the insights, I think, then out of this case? One of them actually is more practical than anything else. So we conducted a hybrid trial, partly in person and partly remotely. And it was really not an easy thing to do. And when we had evidence remotely, not least because we had witnesses who did not speak English. And so we had to have an interpreter. And I can tell you that the pace of taking evidence that way is very slow. So I'm very much all for what I think is the general view at this stage, that although we can continue with short remote hearings, lengthy hearings, or any hearings where evidence is to be taken, I think it's much better in a physical courtroom. Secondly, as I've said already, I think the case shows just how difficult it is to advance forgery claims, as shown in 2 dismissals of arguments which were not unmeritorious at all in relation to the 2016 will and the 2007 will. Thirdly, the technical Section 9 arguments may not get you anywhere in a will dispute if the court is disposed towards upholding the testator's intention. Fourthly, I think it's very much a further demonstration, this case, of the heavy burden you have of overturning the plain meaning of a revocation clause in an international will that's later than the earlier will you're trying to rely on, even where that revocation might result in, say, an intestacy of the English estate. As I've said, it's the first reported authority on the effect of an annulment in relation to severance of joint property. And finally, just with reference to the Indian expert which Jaswinder employed, I think it shows the importance of very carefully scrutinizing who you're going to instruct in terms of foreign experts if you have evidence of foreign law or evidence of foreign forensic evidence. And then I said the sequel, question mark. And I say that because, as you were seeing earlier, that there were a number of issues which were not dealt with at the first trial. And what the court's going to have to go on to consider now that we've got an intestacy of the English estate is who benefits under the intestacy. Is Jaswinder the surviving spouse, or was Diljit? And then also with a reference to whether Indian law or English law will apply to the movable assets within the estate, which are not in India. The court will also be considering whether Hartar died domiciled in England and Wales. So that trial is set down, I believe, for something like summer 2022. So you may get a next instalment of this at some point. So with that, that's all I've got to say this afternoon. But if there are any questions, please do feel free to post them down in Q&A, or alternatively, you're very welcome to email me afterwards, and I'll come back to you with a response. Thank you.